Good evening. I will be discussing the legal status of Eastern Greenland, or the case of Norway versus Denmark, in line with our discussion in public international law, the definition of treaties. The facts of the case are as follows. On July 12, 1931, the Royal Danish government brought before the Permanent Court of International Justice a suit against the Royal Norwegian government on the ground that the latter government had on July 10, 1931, published a proclamation declaring that it had proceeded to occupy certain territories in eastern Greenland, which, in the contention of the Danish government, were subject to the sovereignty of the Crown of Denmark. Denmark contends that Danish sovereignty existed over all Greenland. In support of this contention, the Danish government advances two propositions. The first is that the sovereignty which Denmark now enjoys over Greenland has existed for a long time. The second proposition is that Norway has by treaty or otherwise herself recognized Danish sovereignty over Greenland as a whole and therefore cannot now dispute it. For Norway, it submits that the area occupied was, at the time of the occupation, was terra nullius, or no man's land. The issues before the court, first, whether or not the eastern Greenland or the whole of Greenland is subject to the sovereignty of the Crown of Denmark. Second, whether or not Norway has by treaty or otherwise herself recognized Danish sovereignty over Greenland as a whole and therefore cannot now dispute it. The ruling of the court. The court held that for the first issue, the whole of Greenland is subject to the sovereignty of the Crown of Denmark. For the second issue, yes, the court held that Norway has by treaty or otherwise herself recognized Danish sovereignty over Greenland as a whole and therefore cannot now dispute it. There are various occasions for which Norway recognized Denmark's sovereignty over Greenland and undertakings for which Denmark's sovereignty over Greenland was recognized by many states. So we have here the Peace Treaty of Kiel, the Stockholm Conference, Commercial Treaty, Antilles Treaty, Island Declaration, Convention on the Greenland Question, Notes, the Christiana Protocol, Exchange of Notes, Diplomatic Correspondences, Modern Agreements, so different conventions from different years. Basically, these undertakings are in a form of agreements between states, or it is called treaties, for which Norway had acknowledged or recognized that Greenland is indeed under the sovereignty of Denmark. And there are also instances for which different countries recognize that Greenland is under the sovereignty of Denmark. So in this second proposition, the court said that Norway undertook not to dispute Danish sovereignty over Greenland in different instances, and one of those is in a form of treaties or declarations. Norway has recognized Danish sovereignty over the whole of Greenland and consequently cannot proceed to occupation of any part thereof. Furthermore, the court considered the various bilateral agreements concluded by Norway with Denmark and by various multilateral agreements to which both Denmark and Norway were contracting parties. And all of those treaties, agreements, undertakings provide that Greenland has been described as a Danish colony or as forming part of Denmark. Also, the court considered the Island Declaration. Finally, Denmark has maintained that under certain provisions of the Covenant of League of Nations of the General Act of Conciliation, Judicial Settlement, and Arbitration of 1928 of conventions between Denmark and Norway for the Pacific settlement of disputes, Norway is likewise bound to abstain from occupying any part of Greenland. So treaties as defined is an international agreement concluded between states written in form and governed by international law. A treaty is an agreement between sovereign states. It can be bilateral, multilateral, and it can be commonly known as agreement, conventions, protocols, or covenants, etc. So there are key terms used in the UN Treaty collection. We have here agreements, charters, conventions, declarations, exchange of notes, memoranda of understanding, modus vivendi, protocols, signatories and parties, and all of these are called treaties. So that is my report. I'm Raf Dari S. Santillan. Thank you very much.